Good afternoon. Thank you for joining us. My name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. I'm thrilled to welcome you to today's event, Juvenile Justice: Why Reform is Needed Now. This is a historic year for these issues in Maryland, with a number of key bills currently before the Maryland General Assembly. I'm going to leave it to our phenomenal group of panelists who are deep in the weeds of this important work to talk us through many of the specifics. But I will emphasize an important reality at the outset, which is that when it comes to a number of current policies and practices, Maryland is out of step with both research and with states around the country when it comes to treating kids like kids. Notwithstanding what we know about adolescent brain development, how to effectively address trauma, treatment, and prevent recidivism. For example, last year, Maryland sent more children to adult court than California, Pennsylvania, Massachusetts, and Arizona combined. Only Alabama transfers children to adult court at a higher rate than Maryland. We also know that, like so many issues surrounding the criminal and juvenile legal systems, there are profound racial disparities. For example, 81% of children charged as adults in Maryland are Black. The bills we'll hear about today begin to address these issues and more. I will be moderating our session, and again, I'm so grateful to be joined by such an impressive and inspiring group of panelists who will walk us through what's at stake for youth impacted by the legal system, how these reforms compare to trends across the country, and how our audience members can get involved. So I'll do some brief intros. First, we have Jenny Egan. Jenny is Chief Attorney in the Juvenile Division of the Maryland Office of the Public Defender, a position she has held since July of 2018. She joined the Public Defender's Office as an assistant public defender in 2012. Jenny is also co-founder of the Baltimore Action Legal Team, a nonprofit that provides legal support to Baltimore communities as they protest injustices rooted in structural racism and economic inequality. We are also joined by Anissa Khan. Anissa is an assistant public defender with the Maryland Office of the Public Defender in the Juvenile Division in Baltimore City since 2019. She spent 2 years as a Galt Fellow at the Galt Center in Washington, D.C., working on legal and policy initiatives to improve juvenile defense. She is a 2017 UB Law grad, where as a student, she worked in both the pretrial justice clinic and the criminal practice clinic. And prior to law school, she worked for the United States Department of Justice Civil Rights Division, where she provided litigation support on investigations related to police misconduct and abuse. And last, but certainly not least, we are joined by Michael Singleton. Michael grew up in Baltimore, where he attended Gilman School and went on to attend both Oberlin College and Towson University. For the past 10 years, he has served as a chef at the renowned Black Sauce Kitchen in Baltimore. And we're particularly grateful, Michael, for your willingness to offer your insight based on your personal experiences with the system. A final note to the audience before we jump in: we are very much looking forward to your questions and comments, which you can submit throughout the event using the Q&A function on your Zoom dashboard. We'll get to as many of these as we can. And I also want to acknowledge before we jump in that there is likely a range of expertise, roles in the audience today. And that if anyone wants to pose a question that's not related to any of these particular bills, but on juvenile justice or juvenile justice reform more broadly, that you would like our panelists to help explain or break down, we welcome those questions as well. So with that, we will dive right in. I'm going to start by posing a question to help lay a foundation for this discussion, which is, what are the most important bills in session right now and what challenges they address? And Jenny, I will go ahead and start with you.
Great. I'll start off. There are three really huge juvenile justice bills before the legislature this session. Any one of them would be one of the most monumental bills in youth justice reform that we've seen in quite some years. The first one is the Child Interrogation Protection Act. This would currently, under Maryland law, there is no requirement that that parents know or are notified before their child is interrogated by police. And children are often read their Miranda rights by police in a very coercive manner. The bill would do three things. It would make sure that parents are notified when their children are arrested and are going to be interrogated. It would allow a child to speak to a lawyer and a lawyer to explain their rights and answer questions and help advise them about whether or not they want to speak to police. And it would call for a simplified Miranda warning. So those are the three things that it would do. The second bill, and this is a very big one, would end the automatic charging of juveniles in adult court. Right now, kids are automatically charged. Kids 16 and 17 are automatically charged in adult court for more than 33 separate offenses, including some misdemeanor offenses. As Heather pointed out at the start, we automatically send more kids to adult court than most other states. And we're second only to Alabama in the nation for how many kids we automatically charge in adult court. Almost all of those children are Black or Hispanic. It is a stain on Maryland's reputation. It's also one of the reasons that we were ranked last in the nation for how we protect the human rights of kids by Human Rights for Kids in 2020. The third and final bill is sort of a juvenile justice omnibus bill, a big bill with lots of things in it. It came out of the Juvenile Justice Reform Council, as did the recommendation to end automatic charging. The Juvenile Justice Reform Bill does four big things. It sets a minimum age of jurisdiction. Since 1994, there's been no floor, no minimum age for how young you have to be charged in juvenile court. That's why we see kids as young as 6, 7, 8. When I started as a public defender in 2012, a significant portion of my docket was 9, 10, and 11-year-olds for school fights or stealing Pokemon cards, low-level things that happen in elementary school. So the omnibus bill would set a minimum age so that we stop bringing elementary school kids into court for bad behavior. Second, it would ban incarceration for first-time misdemeanor kids. So prior to the pandemic, 2/3 of kids incarcerated in cages in Maryland were there, and their most serious offense was a misdemeanor or a technical violation of probation. In fact, all young women sent to youth prison in Maryland in 2019, none of them had committed a felony. Not one. All the young women that we sent to youth prison, none of them had committed so much as a felony. The third thing it would do is make diversion easier, get rid of some of the technical barriers to diversion. And the fourth thing that it would do is set developmentally appropriate limits for probation for young people. Right now, all youth probation is indefinite. I don't know if you've ever tried to ground a child indefinitely, but they really don't grasp the concept. And so those are the three big bills: interrogation, ending automatic charging, and an omnibus juvenile justice reform. And I've put in the chat links to the graphics for those that have bill numbers attached to them, if that's your thing.
Great. Thank you so much for that. From there, I'd like to ask, from your personal experiences, what makes these reforms so necessary? And Michael, I'd love to start with you.
When I was 17 years old, I was charged as an adult. I found a gun outside of a party. I brought the gun home. Months later, I had some friends come over. We were playing video games. I was showing off the gun. The gun went off. I shot my friend in the leg by mistake. And I was charged with 2 or 3 felonies, but it was an automatic adult charge. I was 17 years old. And one of the things I realized about that experience was the only thing that really saved me is that I just had access to resources that a lot of people didn't have. For instance, my father went downtown with me when I got interrogated, and my father used to be a practicing attorney. So even his presence being there for me changed how I was treated and how I interacted with the criminal justice system. Because I had somebody there with me who knew how to navigate it. I also feel like the fact that the case immediately got kicked up to adult court was just traumatizing. You know, like in no other aspect of my life was I was an adult. I couldn't do anything adults could do. I was trying to be grown, but I wasn't. But now I am facing this adult charge that now I have to try to get kicked down back to juvenile court. And the reality of it is that I wasn't an adult. Like, I didn't have the mind of the adult. I didn't realize the consequences of my actions, even though on the surface I did an adult thing. You know, I picked up a gun. I was in possession of a firearm. I mistakenly shot my friend. And it could have went badly. I'm not sitting up here saying that it didn't. I got really, really lucky. He got really, really lucky. We all got really, really lucky. But at the time, I didn't understand the consequences of it. So I feel like for us to automatically have charges that, no matter the age of the kid or what they did, automatically kick them to adult court, I think is a mistake, because we're still not dealing with adults. If a child drives, or a 12-year-old drives their parents' cars, that is an adult action. That does not make them an adult. And I think that we can't look at the actions that a person takes and then assume because they're doing things that adults do, that now we can treat them as an adult. And I think we're very selective about who we want to treat as an adult and when. Mature kids can't vote until they're adults. And I think that it's unfair for a child to now be charged as an adult. So like, even if we just took one of those bills and the interrogation, like that would, I feel like, change, not everything, but it would be a boon to the kids that are involved, because it's like, when you go downtown and talk to the police, it's stressful. And you're in a strange place, you're around people with guns, you have these preconceived notions about police. If my pops wasn't there to guide me through the process, I don't really know how it would have went. I don't know what I would have said. I don't know. I wouldn't have been able to navigate that. So I think that especially those two, speaking from my personal experience, had they been in place, even for me, it would have still gone the way that it gone. But I think about all the time, all the kids who didn't have access to what I had access to. And I can't even imagine how they would navigate that. And having those two things as law would give them a chance to be able to navigate that system the way I was able to navigate it. And the way I was able to navigate it basically saved my life.
Thank you. Anissa.
First, I want to say thank you to Michael for sharing that personal story. So my involvement in the juvenile legal system is significantly less than the other panelists on here, and even some of our participants. And I'll share that when I was a law student at UB Law, I had an erroneous belief that children were seen as sympathetic, and so they face less collateral consequences as being a part of the juvenile legal system. The reason why I think that these bills are so necessary is because they address the lived experiences of our clients, specifically the prevalent rates in which our clients face higher mental health concerns, the trauma histories of our clients, and their special education needs. Specifically, the limitation of incarceration for technical violations of probation, the increase in ways in which diversion could be used would be significant for our clients. And it takes into account the increased risk of detention and incarceration for children. So we know that studies show that there's increased victimization and increased recidivism. School dropout is higher. There's long-term physical and mental health issues, and those are compounded when you take into account the mental health disorders, trauma histories, and special education needs of our clients. And so specifically, representing children who are alleged to commit low-level offenses, and then having them incarcerated with youth who have more contact with the system and are alleged to commit higher offenses. There have studies that show increased recidivism because of that peer contagion. And these bills acknowledge that. It also acknowledges adolescent development, which very clearly outlines that SCOTUS has also acknowledged that the brain development and the brain science of children is different. They make decisions using a different part of their brain in which they cannot make the same conscious decisions that adults use, and they should not be treated as adults because of that.
Definitely. Jenny, is there anything you want to add on this one before we move on?
I just wanted to say really quickly, separate from personal experiences, although I do think that these are necessary. My stepbrother was automatically charged as an adult and sent to an adult prison when he was a 16-year-old child. And it's forever scarred and shaped, not just who he is, but our family. It is an ongoing trauma. And so I wanted to say that these are necessary for those reasons that are really personal. But I also want to talk a little bit about why these reforms are necessary and the history of this system. So the narrative around the juvenile justice system is that it was invented and the first juvenile court was 1899 in Cook County, Illinois. All of that is true, but that's not the origins of the system, right? That's the formalization of it. The origins of the juvenile justice system in Maryland come from slavery and the Civil War. And I don't say that as an abstraction like it might be in California, which wasn't a state at the time. Maryland literally created the definition of delinquency during the 1860s. We opened and built Cheltenham, which is a still operating youth jail and prison, as the house of reform for the C word children, using a way to describe Black children. And that system defined delinquents as kids without proper parental guidance. So who didn't have parental guidance? All the freed Black children who were flooding into Baltimore after the Civil War ended. So this is a Reconstruction era. And what they did is they took all those kids who had been separated by slavery from their parents, they sent them to Cheltenham and they did convict leasing. So then they took those teenagers and they sold them back to the plantations where their parents and grandparents had been enslaved. That convict leasing of children happened in Maryland well into the 1930s, and there's some arguments that it happened in the 40s and the 50s. So the laws that we have now, the structure that we have now, the fact that we charge children as adults comes from the origin and the institution of slavery in Maryland. The definition of delinquency comes from the desire of extrapolative capitalism to take Black and brown bodies out of their homes and to use them for labor and for the economic benefit of white people in the rest of the state. So one, I think it's necessary to know that history and to know that every 15 years, a commission like the Juvenile Justice Commission that made these recommendations, every 15 to 20 years since 1898, has there been a commission that has made these same recommendations? For 125 years, the same recommendations have been made. The Baltimore Sun, well, it wasn't the Baltimore Sun, the Afro headlines in 1930s say the same thing that the Baltimore Sun headline says today, which is that this is a system that is too cruel, too harsh, and punishes children as if they were adults, which creates more problems than it solves. So I just want to say that these are necessary because this is a long historical stain. We have done violence to Black people for generations, and the system was built to do violence to Black people. And that's why we must make these changes.
Thank you so much for that. I think building off of that, that's a perfect segue to this next question, because we're laying out this mountain of research. We're laying out this kind of profound and clear history that's gotten us to this point, and everything on the record that talks about what we know surrounding these issues. So how are these measures doing currently in the legislature? And what do you want to share around obstacles they are facing or likelihood that they will become a reality?
Yeah, so I'll say what I'm seeing working in Annapolis, and Singleton and Anissa don't work there, but I would love to talk to you guys about it and know what you think. So the interrogation bill and the omnibus both passed the House last year, but didn't make it through the Senate. They have all had their hearings, and the omnibus bill has already passed the House and is waiting on Senate JPR to vote it out of committee. So right now, child interrogation, ending auto charge, and the omnibus are all stuck or are all currently before the Senate Judicial Proceedings Committee. If they get voted out of that committee, then they go to the floor and there is a fight on those bills. We got very early hearings. We got very good support from Will Smith, the chairman of JPR. He said he supported these bills. He came out publicly for them last year. But that being said, there is a lot of pressure to not move those bills. And there are a lot of people who want them to stay stuck in committee. So the number one thing I think people can do is call their senators and call specifically their senators that are on JPR. I'll put a list in the chat. Call them out, call them on the phone, email them, tweet them. They really pay attention to that, and ask for them to vote it out of committee. The pushback that we get generally tends to be about public safety and this fear of crime or fear of juvenile crime, based not in fact, based not in numbers, but based in perception. What we know and what the research has shown across every studies for more than 20 years, consistently, hundreds of studies have shown, if you take the same kid with the same charges and you charge them in juvenile court, and you take that same kid and charge them in adult court, that the kid charged in adult court will go on to commit more crimes that are more violent for longer. So their criminal career will last longer, and that they will commit more crimes. The answer for me is the pushback on these measures is often that this will hurt public safety. My answer is that these tough on crime, super predator laws that were passed and that have been made really bad are the reason that we have so many challenges around public safety that we do today in Baltimore, and that these bills are public safety measures. But I would love to hear what Singleton and Anissa are hearing from, non-wonks or from people who actually talk about these things in settings outside of Annapolis.
I don't know. I think public safety is a real concern for people, and it's tough when you are seeing something. Like, I live in Highlandtown, and the block that I live on is really, really active. It's a lot of people outside on my block. There are a group of young men that are on Lombard Street that they're not there anymore, but they outside selling drugs all the time. Like, that's just a reality. My wife doesn't feel comfortable walking on Lombard Street by herself. Like, that's real. Like, and I think that perception, even though that perception isn't reality, I think that perception becomes more real than the reality for a lot of people, because that's their lived experience. And I think that one of the mistakes that we make when we're addressing these things is like you hit people in the head with facts, but the facts don't erase away how you feel. And I think that part of what the problem is that a lot of people have limited context as it relates to Black and brown youth in this city, right? So if you have limited context and you're not interacting with anybody, you're not interacting with people outside of the people that you hang out and look like and be around, especially young Black and brown kids, then anybody can create the context for you. That's why it's easy to think about them as all being criminals. That's why it's easy for all of them to think about being super predators, because people have limited context. And I think the only thing that will really, really change people's perceptions is if we can change the context in which these kids are being perceived, broaden the context to give them more ideas about who these children are and what they are doing, outside of the very easy thing to do is that, they criminals and they threaten public safety, and they make you feel afraid. I know that's a real fear for individuals. I got a homeboy who grew up in the city, who's leaving the city because of that. But I think that even for him, like, you buy into this narrative that allows you to make the decision you want to make. So now the reality of the situation isn't as important as the perception of the situation. And I think that is one of the hindrances for people. And I think that of the problems really is that like, it's not, the issue for me is that the law is not equally applied to everybody based on the crime you commit. If somebody did the same thing that I did and didn't have the access to the resources that I had, they would have been in jail. We committed the same crime. The crime wasn't what the issue was. It was the access resource that I had that kind of shielded me from the worst things that could have happened from the justice system as it relates to what I did. And I think that's what ends up happening a lot of the times, that the kids in this city don't have access to those resources. So now they get hit with a harder stick than anybody would have, even if they did the same thing as somebody else that had access to lawyers, had access to people who would be like, this is how you do this. Access to people that would be like, yo, don't pick up that gun. Don't go out there and sell these drugs. So it's not like the crime, the law is equally applied to everybody who comes in front of it. That's not true, because even though I am a Black male, like I was a Black male that had a bunch of privilege. You know what I'm saying? I got to go to private school. My dad was a lawyer before I was born. My mom was a human resources professional. I had this group of people that could protect me and kind of shepherd me through my life, not just through this particular situation, but just through it all. And I think that the reality of it is that a lot of kids don't have that. So if you don't have that, and you don't have this connection to resources that kind of shield you from the worst that the system has to offer, the next best thing we can do is change those laws so now they are evenly applied amongst those kids that come into that system. I think the context thing is something that takes a lot longer. But I think if you want to, because now you're trying to change hearts and minds. I think what the laws do is allow people to change behaviors, and it can change it immediately while we give these people who are pushing back against this as it relates to public safety the proper context for them to realize that all these kids that are in this system and committing these crimes are not forever criminals. They're not menaces to societies. Or some of them, yes, but it's a lot less than what you think. And I think that is a longer conversation, and that is a longer process. But I think in the meantime, these laws allow us to immediately change the behaviors to get those kids out of the adult court that we, like Jenny just said, that they're going to be treated. They're going to become these true threats to public safety if they get charged to adult court. They have a higher instance of being able to do that, and keep them in juvenile court where they have a chance to be their best selves. You know what I'm saying? And I think that these laws help us do that until we can change the perception of those people who are pushing back against these bills passing.
Anissa, do you want to jump in on this?
Just briefly, I mean, I think Michael's point about the bias or the limited contact with Black youth and youth of color, it has a word to it. It's called confirmation bias. And confirmation bias is used in a lot of the narratives to push back on some of these bill reforms, right? Where they're telling a story out of context that the data does not support the stories that they're telling in these narratives. Jenny has run lots of numbers based off of what arrests look like in Baltimore City and statewide over the last several years. And it shows that the arrests are significantly lower. And in terms of individual success for each of our clients, we're able to connect them with appropriate services, individualized services on an individual basis through litigation in each of those individual cases. And that's how young people are provided with support to make better choices and to do better. This one approach doesn't work. It hasn't worked for anyone. And what the bills do is that they allow those individual approaches to happen more for each of those individual children. I've recently represented a child who we were negotiating, getting the case. I was negotiating with the state to get the case diverted out of the juvenile legal system. And I asked my client, well, what would you benefit from? And he's like, you know what? I really want a mentor. I want a mentor to help me with these specific goals that I have. I want to get a job. I want to do this. And he had distinct goals that he felt like he would benefit from mentorship. And that is what we did. We diverted his case out and we connected him with those services. A lot of our clients know what they need to better support them and to find ways to connect them with those evidence-based, community-based services helps them more than putting them through the system and attacking it with a one approach for every kid without recognizing their individual needs.
Thank you. And I want to acknowledge a question in the chat. How do critics, including prosecutors, respond when presented with the data that's been coming up in this conversation already? I know we're starting to talk about some of these tensions around these realities in the system, around the research, around the data compared with some of the pushback. But if there's more that the panelists want to add about that.
I'll just say that the Maryland State Attorneys Association has come out in opposition to the interrogation bill ending the automatic charging bill. They don't take an official opposition to the Omnibus bill, the large juvenile justice reform bill, but they don't support it either. It's sort of a neutral position. Their critique of the interrogation bill has often been that if kids know their rights, they'll use them, and that will hinder investigations. My response to that if you have a problem with that, then you have a problem with the Constitution and not with this bill. But kids have a right to know their rights. Their opposition has. I don't know how to characterize it more generously, although I could probably try. But generally, their argument is that these are necessary, that there are exigent circumstances, all the things that as lawyers, we can craft and fix exigent circumstances. We can craft and fix procedural things. When it comes to the substance of the fact that children don't understand their Miranda rights and give them up 90% of the time, there isn't a real response to that, except for to say, nobody wants false confessions. Nobody wants those things. They want to allow police and prosecutors to work on better policies rather than having something across the board, or rather than having them simply have access to attorneys. And so that has been the general response. For ending automatic charging, state's attorneys state's attorney had a representative on the Juvenile Justice Reform Council. They were able to bring research or experts or anyone to bear on that conversation. They brought not a single study, not a single expert. No one came to testify about why it benefits the state or public safety or children or anyone. But on paper and in arguments, they argue, one, that children should stay in adult court, that some crimes are so horrific that they demand adult incarceration. And then some of the critiques are also that there may not be enough time in the juvenile system. So say a child is 17 when he commits a very heinous crime and the juvenile system ends its supervision at age 21. To that, I would respond that one, the time in adult and time in juvenile is very different. In adult prison, you are warehousing people. There are not programs. There are not access to education. There is not things that you have to do. And what most young people who are subjected and much more likely to be assaulted, both physically and sexually in adult facilities. But two, there's no school. There's nothing you can do. So most kids I know, and I know lots of kids who have been transferred to adult prisons at midnight on their 18th birthday. What they do is they do one of two things. They join the roughest, toughest crew with people they know from home to prove that they're not someone to be messed with, or they hide, right? Just do everything you can to keep a low profile. That is not exactly rehabilitation. The difference between time in adult and time in juvenile is that time in youth facilities is called active accountability. A young person has to go to school. They have groups that they have to participate in. There's counseling and there's active accountability, which means that that's why we know that the youth system is so much better for young people. That being said, I don't even think that argument is very relevant to this bill, because this bill does not end the ability to try kids in adult court. It only changes where kids are charged. A judge still gets to decide if a kid or the crime is so serious that it needs to go to adult court. Nothing about these changes or reforms would interrupt that. And so in the end, I think that critique is more a fear-mongering tactic and a scare tactic than one that addresses the substance of the actual reforms we're proposing.
Thank you. Want to move to, again, kind of place this conversation in the national context. We've talked a little bit about how Maryland is out of step with a number of other states on some of these policies. So I'd love to hear from any of the panelists, but Anissa, can we start with you?
Sure, I'll speak more. I'll leave automatic charging to Jenny, who has much more experience in it than I do. But regarding the youth interrogation bill and the Omnibus bill, for youth interrogation, many states have passed similar legislation. They have passed laws that both give Miranda warnings, require Miranda warnings to be given in youth-friendly language. And so we know currently the Miranda warnings are given at a much higher reading level than most of our kids read at. So most of the clients that I represent have individual education plans or 504 plans. And within their IEPs, I see that their reading level is perhaps at a fourth grade level. Some of my clients, it's at a kindergarten or first grade level. And so they don't understand when a piece of paper is put in front of their face and they're told to read it and sign it. They don't, and I ask them later, well, what did that mean to you? And they can't answer that question. They had no idea what they were signing. In terms of the Omnibus bill, well, we know NCJFCJ, which is the National Court of Juvenile Court Judges and Family Court, they've said that young people should not be incarcerated for technical violations of probation. They should only be incarcerated when there is an actual risk of the community or a risk to the child themselves. I've represented a child who had an IEP, was receiving special education services, and she had a behavioral intervention plan. So she had a documented diagnosis, had manifestations of that diagnosis outlined, which included outbursts within the school environment. And the school was required to follow a certain level of responses to when those manifestations occurred. Well, the school's response was to call in school police, who escalated the situation, and she was charged and then adjudicated for disorderly conduct within the school. Well, then a year or so passes while she's still on probation, and she finds her uncle murdered outside of her home, and then proceeds to miss the next 2 weeks of school while she is grieving upon finding her uncle. Well, a violation of probation was filed in her case, and her probation was rescinded just on the technical violation of missing school, and then she was committed to placement. And so these stories they're not things that happen every once in a while. Like we heard recently the national story of Grace, right? Who's similar circumstances. She missed school or didn't turn in schoolwork, and her probation was rescinded and she was committed similarly to my client. But these aren't stories that just exist in these are happening on a regular basis, right? Where kids are being incarcerated for technical violations, not meeting with their probation officer or DJS case manager, missing school, even despite traumas occurring within their lives, right? We're not providing them with the right responses. Rather, we are locking them up and exacerbating the trauma that they're experiencing, removing them from their family while they're grieving and trying to learn how to navigate those feelings and those experiences. And that's not helpful for any child, and especially when in a system that is arguably premised on rehabilitation.
Thank you for that. Jenny, Michael, more that you want to add about how does Maryland compare?
Oh, I should tell you, Maryland's bad. So Maryland is ranked by Human Rights for Kids as one of the worst 6 states in the union for how we treat the human rights of kids, because we don't have minimum ages, because we send lots of kids to adult jails and prisons, because we don't protect basic protections. But also, like, we're talking about setting a minimum age. New Hampshire is closing all of its youth jails and prisons because there are better ways to treat kids and because there are more effective ways of doing it. California passed a Child Interrogation Act more than 2 years ago. It's been in effect for, I think, 18 months. We are 27 states have narrowed the path to adult court, including California. We are a good 15 years behind on basic juvenile justice reform. And if these bills don't pass, other states are starting to lap us. Internationally, like, just so you know, international law and to become a signatory to the UN Convention on Children, we would have to create a minimum age of 12 and move towards 14. We would never be allowed to try kids in adult court, let alone automatically charge them. Our criminal legal system is the reason we are not a signatory to the UN treaty. It's us, and I'm going to forget. There's only one other country that allows what we allow to have happen. Someone in the chat, that's correct.
Thank you, Rebecca.
A civil war.
So I want to expand this question a little and start with you, Michael. Clearly, there is a lot of work to do. What else do we need to be thinking about and prioritizing that's not on the agenda this particular session, but should be in the near future?
I thought about this before when you sent out the outline. I don't know. The biggest thing I think about is that you need people who are in the system who can relate and have context for the kids who are entering the system. Without that, then it is very, very, very hard to have the system treat the kids fairly. I watch a lot of football, and recently a head coach that was the ex-head coach of the Dolphins, Brian Flores, sued the NFL for discrimination, saying that Black coaches don't really get a fair shake. They have this rule called the Rooney Rule, means you have to interview at least one minority candidate, and he was like, they don't live up to that. And I was reading the tweets of one of the players that's in the league, Kenny Stills, and one of the things he said is that won't really change until there are more Black and brown GMs, presidents, and owners. And I think that's very, very, very true, because you have a natural inclination to understand the people who are a lot like you, right? So when this Black coach comes up in front of these white GMs and they don't have the context for him, certain things he can say or do can be off-putting to them. And then they just, they don't want to hire him just because he's unfamiliar. And I think that happens a lot in the criminal justice system, and particularly in Baltimore. You have cops, judges, state's attorneys who don't, I don't even think that you have to necessarily be from Baltimore. I don't even think you necessarily have to be Black or brown. But I think that one of the things we need to seek out and train people to have is this context and familiarity, because then you can put this child's actions in its proper context. One of the things that critics do, and I think Anissa said this, is that you tell a story and you remove all the context from it. And then when you remove the story, when you remove the context from it, then it's like, oh, damn, yeah, this kid is wild and we do need to charge him as an adult. But the minute you start adding a little bit of context, where they from, who their parents are, the trauma that they have, now you paint a fuller picture, and now automatically the kid starts looking like a kid, or looking like a person first and foremost, and then start to look like a child. So I think that one of the things that has to happen, and I don't know how this happens, but I know that even for me, when I was in situations where people kind of, even if you didn't have the context, they knew they didn't have the context and they were trying to get it, it changes everything. Because now, when these kids, even I'll speak for myself, now I'm less on guard, I'm less angry. I act out less because I have less to prove. I'm in a place where I feel comfortable. And I think you have to have eyes and ears on these children that kind of understand where they're coming from and what they're going through. I think without that, then you'll always be relying on laws. And then even when you have those laws, you have people who have to adjudicate those laws. So then it's a lot of leeway when it comes to that. I think that for me, and I know this is longer term, and this doesn't negate anything that's happening now, because I think these things need to happen. But I think that the thing that will carry it is that you have to have people who either have the context or have the desire to have the context for these children that are in the criminal justice system. To first humanize them and realize that their lives have value, because without the context, then their lives don't have value. And then it's easier to now cast them away because you don't think that they are worth anything. The part of the reason I was treated differently by the criminal justice system is because people throughout the way, based on my parents, where I went to school, they thought I had value. And because I thought I had value, they had context for me. They had kids that went to Gilman. My dad was a lawyer. He could talk to other people who were lawyers. Because they determined my life had value, now the criminal justice system treated me differently because now it's like, yo, this is a kid we can save. But a lot of these kids are kids that we can save. The problem is that we don't have people who can give them the proper context to realize that first to humanize them, to realize they have value, and now to then treat them like children. And then to believe that now these people who are children are worthy of these services that now can truly rehabilitate them. And then they can be productive members of society. I think part of the reason you see all this pushback is because people don't believe that can happen. And the reason why they don't believe that can happen, one of the reasons why is because they don't have the context for them. And if you don't have the context, then it's easy to cast them out. It's easy not to invest in them. It's easy to keep the status quo because you just don't think it's going to be any different regardless of what you do. And the reason why you feel that way is because you have no conception of who these people really are or that they people to begin with.
Thank you, Michael. I want to give Anissa and Jenny an opportunity also to weigh in on this. Besides getting these bills past the finish line, what else is on the agenda?
I never want to follow up after Singleton. Because I'm just thinking about, just if there are law students and lawyers on here, like that's the other thing, right? Like my job is to represent children and to try to humanize them to people who don't know their context. And like, why do I get to do it? Why do I, as a white lady not from Baltimore, get to do that? And how do I do that? How do I erase their humanity all the time? But all right, we'll talk about it later. The other things that have to happen, the fiction of felony murder. It is a legal fiction that is a cruelty in our legal system that should never exist. If two people stand side by side and commit a robbery and one pulls a trigger and one doesn't, the person who didn't pull a trigger is not culpable in the same way. We have to get rid of felony murder. But when you take it down to kids, it's absolutely an unconstitutional thing. And the majority of children serving sentences of more than 30 years, and they're no longer children, old men across prisons in Maryland are there, and they never, ever killed anyone, but they are there for murder. So we have to get rid of the legal fiction of felony murder as it applies to children. That's my number one. And frankly, we need to close youth prisons. That we have, our youth prisons are horrible places that create more criminals than they heal. I don't even like that term criminals. That's not even what I meant. I'm just saying they build and create criminogenic behavior because it is a mode of survival. And it is what when you send a child to a place, they're going to learn what that place has to offer.
Yeah, brings us back to the public safety considerations surrounding the bills. Anissa, do you want to weigh in on this one?
Briefly, I'll say primary for me and for many of my colleagues is getting police out of schools. I grew up in New York and we didn't have police officers in our schools. And I constantly, as a frontline defender, am coming across cases in which I'm like, really? Why are you in the system? Like, why isn't this just a detention or a short-term suspension? And the issue is, especially in Baltimore City, is the Baltimore City School Police manual specifically says that once they insert themselves into a school incident, the principal, the teacher involved, whoever the administrator is who is overseeing that incident can't kick them out. They have no control over the situation once Baltimore School Police decides to insert them out. One of my first cases that I handled in my office was for a young person who was charged with a school offense. And the school's response to that, the allegations, there was no response. My client didn't serve any detention time. They weren't suspended because when they looked into that incident, they saw that my client didn't do anything wrong. But then we had to fight it in the juvenile legal system before that case was ultimately dismissed. And that took 2 months to do. When from the beginning, the school's investigation showed that my client did nothing wrong, but because school police had inserted themselves and then forwarded that information to DJS, who then forwarded it to the state's attorney's office, my client had to come to court more than once to litigate this issue in which there was no wrongdoing on his part. And that is, to me, unconscionable.
Thank you for that. And before we move on from this one, I mean, because public safety is such a consistent consideration, because, for example, throughout the country right now, relatedly, the attention in cities across the US around rising crime rates, around gun violence. If there's more any of the panelists want to say about kind of the current frontier of this work and the next frontier of this work around non-carceral strategies to addressing and reducing violence, and also kind of how to talk about and how to keep pushing for reform given that climate and landscape around violent crime.
One, my argument would be if policing and prisons solved violent crime, then Maryland wouldn't have any. Maryland has given more money to police than most other states. Maryland has funded Baltimore police, given them more money, 10%, like year after year, we give them 10%, 10%, 10%, 20% more for generations. It has not worked. It does not work. So we need to start looking at what works and what we know about young people. The thing that, and I'm sorry to all the young people are listening, but the thing that makes a teenager dumb, and teenagers, I kid you not, are dumb, right? Like just developmentally, their brains are undergoing changes. They have less impulse control than they did when they were preteens, given how adolescent brain development works. But the thing that makes a teenager dumb, the thing that makes kids more subject to peer pressure, unable to think about long-term consequences, unable to plan or think about what the effects of their actions will be, those same things are the magical things that also mean that kids are more malleable and more subject to rehabilitation, right? So the kid in the worst circumstances, who has the biggest challenges, who has seen and experienced the most violence, what Singleton said is it's also this hopelessness, right? This vision, this idea that if they did that at 16, there's no way they're going to be okay. We have to push back on that narrative because it's not true. What we know is that kids of all races and classes commit the most amount of crimes. And then the minute they turn 23 and 24 and they start not being dummies, no offense again, then the amount of crimes and bad behavior they report goes down significantly. So I think we need to start talking about our kids with hope and to start really envisioning a world that we want to live in. And the world I want to live in is one where, do you know what? Like a group of 5 17-year-old kids on the street is intimidating to anyone because I know they're going to act a fool, because they're going to show off for each other, because they're going to be silly, because they're subject to peer pressure. But I also know if I pull any kid out of that group and I talk to them really about what they want in life, there is so much potential there and so much that we can do for young people. We just have to start thinking about systems that exist outside of prison and outside of punishment.
Thank you. And I don't see any current questions that are outstanding, but I do want to acknowledge a couple of the recent comments that have come in. One around the amount that we're spending currently around the consent decree and monitoring, big question around resources there. And then also that we can't talk about juvenile justice reform without talking about education reform, which I think is a really important point. And if there's anything that the panelists want to jump in on either of those fronts.
I really like the comment about you can talk about juvenile justice reform without talking about educational reform, because I think that, I mean, it's true. I think that all these issues that we are facing, they're so interconnected with other issues that need to be addressed in order for this thing to be addressed. Because if we aren't educating the kids. Mental health, you can't talk about criminal justice reform without talking about mental health, the way we address all these different issues, because there's so many things that are affecting us as people, and even more so affecting children, because the children don't have the natural defenses to be able to navigate all these different things. So I think that one of the things that we can do is just talk to people, even if you're passionate about criminal justice reform, talk to those people that are in different industries that are dealing with kids in a different way, and have those conversations to try to figure out what else is needed in order to help our children. Because a lot of issues that our children are facing, it's a myriad of things that put them in this predicament, not just the one thing. And if you can't address, you don't have to address all of them, because you got to kind of break off the piece that you can fix. If you look at it all, then it can be overwhelming. But I think the least a person can do is then have a conversation with those people who are dealing with children in different ways, to try to come up with a holistic way to give these kids what they need, all the way around, just as it relates to the criminal justice system. Because it is really, 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 really all interconnected. There were so many different things that had to work in order for me, and I damn near had everything. You know, I had two parents. My parents made good money. I went to private school. I needed all of that to even have a chance. And even then it was hard, you know, and I had a lot of those things in place. Like, I had a world-class education. I lived in my neighborhood wasn't the best, but my neighborhood was my neighborhood. Everybody looked out for each other. So I had a lot of those things clicking for me, and it was still a dice game for me. It could have went the other way. And I know that kids that don't have that, then it's like they really, really facing an uphill battle. So we need to address all those things. And I think we need to have conversations with those people so we can figure out the best way to address it, and then work together as it relates to how we solve all these issues.
I think that's such powerful and important wisdom in our closing minutes here. Before I give each of the panelists kind of one last chance to make any concluding remarks, I want to acknowledge all the important information that they're putting in the chat around what you can do to get involved, and give anyone an opportunity to kind of say on the record here any directives or any words for the audience who want to make an impact right now on these bills.
So you can go to www.mdcarenotcages.com. It's a quick and easy way to email your senator and express your support for ending automatic charging. I put some links in the chat too, to a link tree. The Sun came out with an editorial just about an hour ago. It's going to be in the paper tomorrow, hopefully. But the pressure should be all on your state senators. So call your senators, call Senate leadership, especially Bill Ferguson, especially Will Smith, to let them know that you support this bill and that they need to bring it to a vote soon, soon, soon. Now. The timing is most important, just because it's an election year, so you have to overcome a governor's veto earlier in the session. So please reach out to your senators, especially Will Smith and Bill Ferguson, to let them know you support this. And then just keep talking about it. Keep talking about it, and also keep framing it. I know people are afraid. I know people say things, but the answer is, like, I want to hope for something bigger, and we should be not only is the facts and the figures and the stats are all on the side of treating young people in the juvenile system in more holistic ways, but that's the world I want to live in. I want to live in a world where if we failed a child by not providing them with quality education, if we failed a child by not catching their mental health issues earlier, if a child simply got really mad at the world, at the state of the world. I look outside and I'm mad at the state of the world. I can't imagine what it's like to be a 16-year-old. I just want everyone to remember that a 14-year-old today was born in 2008. A 14-year-old that we send to adult prison for life in this state was born the year Obama was elected. That's how small their life experience is. That is the world that they've seen. The only thing that they've seen are those 14 years, and we deserve better. I want a world that has more for kids. And I think most people do too. I know most people do.
Thank you so much for that, Jenny. Anissa and Michael, any closing thoughts or remarks?
Yeah, I have one. I that the legislation, what's happening in the what's happening with the laws is one way that we can address this issue. But a lot of us don't have, like, we can't go and argue that in front of a house or anybody. A lot of the conversations that we have are with people that we know. And I think that part of this is a hearts and issue, to change the hearts and minds of the people that you interact with, even those people who stand on the side opposed to yours. And I think I would give people two bits of advice as it relates to that. I think that one of the things that we have a bad habit of doing is like divesting somebody of their reality, right? So when somebody comes to you and be like, yo, I'm terrified of these kids on the corner, these squeegee boys terrify the shit out of me, we try to shame them and feeling that. But that fear is real. That's something that they live all the time. And instead of speaking the truth that they are living, we try to take that away from them and then try to give them something that they don't necessarily have the context for. I think one of the things we have to do is we have to acknowledge the lived reality of the people that we interact with. Even those people who have a lived reality different than ours, and because their difference in that lived reality is different, then the way that they look at the world is different. Because then if you acknowledge that, what you can do in that moment is that now you can provide the proper context to round out the way that they feel. A lot of times people have these blind spots that they have, and they don't know that they're blind spots. So they feel the way that they stand on it with 10 toes because that's all they really know. You make the assumption that they know what you know, and then they still ended up the way that they ended up. And that's not the case. They don't know what you know. It's like these kids. Like we assume that these kids know everything we know as adults, and they went out here and did this crime. That's not true. They got the biggest blind spots of all. But as we grow up with these blind spots as well. I think one of the dope things about us being in a community with each other is that now we can take our lived experiences and close off the blind spots for those other people. Being like, yo, I know you feel this way, but did you think about it this way? Because now you can get context that they might not have had because you have a context based off of the life that you lived. So I think that when we talk to people, and I know it's frustrating, and I know it can be defeating a lot of the times, but the reality of it is that we need to have conversations with those people who we feel like sometimes are diametrically opposed to our viewpoints. Because once you have those conversations, you realize that they're not really. They just need more context. There are very few truly evil people in this world who just want to see the world burn and want to see people messed up. It's like, that's not really the case. I think a lot of times people just feel the way that they feel because they know what they know, and they're not humble enough to realize that their vision is a little short-sighted. So if you acknowledge a person's truth, then I feel like you can then open up and have a different kind of conversation with them where you can provide them a piece of yourself that they didn't have. And now their viewpoint can become a bit more holistic. They still might not end up where you end up. But I think that now you can start having a dialogue and everybody can enter this moment of self-reflection where now they're looking at a situation differently based on the new information that you were able to provide them.
Thank you so much. Anissa, any last words?
I'll just end with, I love my job. I love what I do. And I love the interaction that I get to have with my clients. They're cute. They're funny. They have me in stitches all day long, even though they're going through some of the most stressful things that a person can go through. But I wish I didn't have my job. I wish my job wasn't needed. I wish we treated children with the compassion that they should be treated with, and we recognize them. Like Michael has said about their lived experiences, their traumas, their mental health concerns, and we responded appropriately. And I do think that these bills take a large step in that direction. I wish they did more. I wish there were opportunities for more reform in the future. But this is a really, really great start.
Thank you so much. I know we're over for by a couple of minutes. We will let you all go. But before we do that, thank you to all of our panelists. This has been such a powerful and enriching conversation. I know I have learned and taken so much from it. Thank you to our audience members. Please be in touch, and we hope to see you at a future event. Thanks so much and have a great evening.